Everyone, welcome to the Law of Torts lecture series. My name is Abhishek Singh Negi and today we are going to talk about strict and absolute liability. But strict and absolute liability is also called no fault liability and there is a reason for it. Strict and absolute liability is coined first time in 1868 in a judgment called Rowland vs. Fletcher. Justice Blackburn played the very important role and gave the judgment, but before talking about the judgment, let's talk about that why it is also called no fault liability. Before the judgment of 1868, the common understanding in law of torts for any injury is regarding the fault theory. For example, there has to be a fault done by the defendant. Taking the example of negligence. In negligence, the plaintiff has to prove that there is a first prima facie duty, the legal duty, and that duty is breached, and if that duty which is there in the defendant and he breaches that duty sustained the injury to the plaintiff. That means there has to be a fault first. But what if there is no fault done by the defendant and even then the plaintiff has sustained the injury? To answer this, the court in England evolved the term called no fault liability. That means even if there is no fault of yours, you are liable. But we have to see that there are certain criteria that not every time the person would be held liable under no fault liability, but there are certain criteria, and if that person, the act of that person falls into that criteria, even only then he or she will be held liable. So let's talk about the facts of Rowland vs. Fletcher. The landmark judgment came in 1868. The facts are very simple. There are two neighbors, Rowland and Fletcher. Rowland contracted with the engineer and contractor, and he is going to construct the reservoir, a grand reservoir, for his own purpose. Now Rowland did not know that there are certain potholes which are connected to the shaft, and these shafts are leading towards his neighbor, that is Fletcher. But after the construction, Rowland poured water, and the whole water through the potholes went to the shaft and ultimately reached to his neighbor Fletcher, and Fletcher sustained injury. Now Fletcher brought legal case against the Rowlands, saying that he has done nuisance. But Rowlands was very sure that since he has no fault, as he did not know that the potholes are connected to the shaft and the shaft is connected to his neighbor's property, so he was very sure that since he has no fault, he won't be held liable. But court extended the understanding of nuisance and said in Rowland vs. Fletcher, the Justice Blackburn said that if a person owns for his own purpose, brings certain mischievous thing, and if that thing escapes, the prima facie liability would be that person, and he has to prove that why that thing escapes. That means there are certain exceptions, and if he would not be able to satisfy the court that because of those exceptions the dangerous thing escaped, he would be liable for strict liability. So let's talk about what are those essential criteria. The first criteria in Rowland vs. Fletcher was dangerous thing. Now dangerous thing means if I am bringing, suppose, tiger into my house and then that tiger escapes. Obviously tiger is a dangerous thing, and if that escapes, it does not matter that whether I have taken proper due care or not, I would be held liable. The second thing is escape. Students, in strict liability, the most important thing is escape. That means if someone comes to my house and then tiger attacks to that person, I won't be held liable. Why? Because tiger has still not escaped. Under escape, the very famous judgment called Cheater vs. Skater, where the poisonous tree has been grown by the defendant into his property, and the tree, the fruit of the tree fell in the land of the plaintiff, and the plaintiff sustained injury due to that poisonous tree. Here, the court held that yes, no matter the defendant has no fault as he did not know that the tree is poisonous in nature, he would be held liable. Why? Because this is the dangerous use and it escapes. The poisonous tree is a dangerous use of the property, and when the fruit of that tree fell into the land of the neighbor, the dangerous thing escapes, and that is why it is called no fault liability and strict liability. The second case would be Mrs. Reed versus Rains. Now, in what Mrs. Reed's versus Rains, what happened was that the plaintiff works in an ordnance factory. This is the factory. In ordnance factory, the plaintiff works, and the ordnance factory is having the work of explosives. Okay. Now on one day, the explosive exploded in the factory. Let me tell you, in the factory. Whether this would be the case of strict liability or not, court said no, this is not the case of strict liability. Why? Because the explosion happened inside the factory, and as this is not escape, here strict liability won't be applicable. Now this third case would be Sarju Prasad versus Mahadev Prasad. Sarju Prasad versus Mahadev Prasad. In Sarju Prasad versus Mahadev Prasad, the defendant did the hole in his land, but the defendant dig the hole in his land, but it exposes the beam of his neighbor, which resulted in the decaying of his neighbor's beam, and ultimately the injury sustained by his neighbor. Now here the court said, now this is the dangerous use of his property, and because he exposes the beam of his neighbor because of the digging of the hole, here now the dangerous thing is escaped, and he is held liable for strict liability. After seeing the components of strict liability, can we say that strict liability is absolute in nature? No, we cannot. Why? Because strict liability is having certain exceptions. The first exception of strict liability is plaintiff's own fault. Now this plaintiff's own fault exception is related to the general exception of plaintiff himself or wrongdoer. For example, in Ponting versus Norgay, the court held that since it is the fault of the plaintiff that his horse went inside to the property of defendant and then he nipped the grass of the defendant, poisonous tree, and that is why defendant won't be held liable. The second case is act of God. The leading case of act of God or vis major is Nicholas versus Marshland. Now the facts of Nicholas versus Marshland are, there are two neighbors, Nicholas and Marshland. One is having private stream and another one is having bridge. Now because of the heavy rainfall, the private stream got overflowed and it damaged the bridge of the neighbor. Now the neighbor filed a suit against the person who is having private stream, and the court said that since this is because of the overflow of the stream and overflow is because of the act of God, as the overflow is because of heavy rainfall, then this is the case of act of God or vis major. The third is the act of third party. In this case, in Box versus Jug, what happened was Because of the third party involvement, the reservoir got overflowed, and because of the overflow of the reservoir, the plaintiff sustained injury. Court said that since here the causation is breaking. Why? Because at the moment third party's role comes into picture, the third party role breaks the chain, and here strict liability won't be applicable. The fourth exception is consent of the party. This consent of the party is also related to the general exception called voluntary not fit injuria, where if you have given the consent of the risk, if you know the risk and you have given the consent to the risk, that means later on you cannot complain about the risk. Here in this case also, in this exception also, consent to the party means if you have already given consent, and thus the consent is generally given to the common benefit. For example, you are living in a locality and a very heavy water tank is installed upstairs in the rooftop, and that reservoir, the water tank got damaged, and because of the damage of the water tank, the many people sustain injury, and even you sustain injury, you cannot complain afterwards. Why? Because it's you who has given the consent for the installation of the water tank. Now the last exception is statutory authority. Now this statutory authority means if the statute has given certain permission or certain authority to certain government organ, then that government organ, if that organ is doing anything with regard to the statute, even only those action would be covered under statutory authority. Otherwise, if the statutory authority, for example, the railway work is there under statutory authority, and if the railway authority could not be able to clean the dry grass laying just near to the railway track, here this act does not come under statutory authority. But if, for example, honking of railway engines, these are the acts, and running of railway trains, these are the acts of statutory authority, and these are exceptions under strict liability. With this, we are coming to the last part of the video, that is absolute liability. Now, after the decision of Rallens versus Fletcher in 1868, the reaction to many countries, for example in America, Rallens versus Fletcher was not absolutely acceptable. They are in the thinking that Rallens versus Fletcher would restrict the development of the economy, because if we will invoke strict liability every now and then the development won't be possible. But in India, we extended the rule of Rallens versus Fletcher, and we evolved through strict liability. We have evolved through absolute liability. Now, what absolute liability is? Absolute liability is, for example, the exceptions which you people are reading of strict liability. No exception is provided to the enterprises. The criteria is, if you are an enterprise and you are involved in any hazardous industry, then if because of your hazardous industry, if some people got injured, you will not getting any of the exception given in the strict liability. That means your liability would be absolute in nature. Now with this we have done, for example, with this we are coming to the last case law, and which is very important case law of M.C. Mehta versus Union of India. Now this M.C. Mehta versus Union of India is also called Oleum Gasly case. Now this case is about Shriram Fertilizer Corporation, where Shriram Fertilizer Corporation in Delhi, they work in the area of hazardous industries, and because of those industries people are getting affected. And because since the strict liability is having certain exceptions, but so LC method thought that what about those industries which are really hazardous, which are working in really hazardous areas, for example, nuclear power plants and for Sri Lanka fertilizers. So he filed a suit against the Sri Lanka fertilizers, and the court said, yes, in this case, Sri Lanka fertilizers are absolutely liable and they have to pay all the compensation to the victim party. With this, we have coming to the end of the video.